If your employees are pasting confidential documents into ChatGPT or Claude, you may have just lost legal privilege over them. Right now, it's a legal grey area, but slowly but surely we can see this is the direction things are going. The idea I want to talk to you about today has nothing to do with analytics or business, but the legal implications of using cloud AI are significant. And if you work in business using these cloud AI tools, it's important you understand what might come ahead. 2 immigration matters came before a tribunal because of the cases that the parties had cited. Some of those cases didn't exist, others existed, but the citations pointed to the wrong court or a different case entirely. This, as we know, is classic AI hallucination territory. In the first matter, the advisor denied using ChatGPT to draft the documents, but accepted he had used it on client communications and Home Office decision letters. He also accepted that one of the false authorities may well have come from Google AI. On the second matter, the solicitor denied using ChatGPT at all, but the tribunal was still concerned enough about the inaccurate citations to refer the matter to the regulator. Either way, the tribunal was unimpressed, and it reminded lawyers that they are responsible for the accuracy of the material they file in court. It reminded senior lawyers that delegation does not remove responsibility, and it has referred practitioners to their regulators. Now that part's fine. That's a story about lazy lawyering, poor supervision, and hallucinated case law. There's plenty of articles about that. But buried inside the judgment was something far more consequential, because they started to address the elephant in the room. What actually happens when confidential or privileged material is uploaded to a public AI tool? And here's the tribunal's position in plain English. Uploading confidential documents to a public AI tool such as ChatGPT places that information on the public domain. The result is a breach in client confidentiality and a waiver of legal professional privilege. That's huge, right? That's the clearest statement yet from an English court or tribunal that public AI tools destroy confidentiality and privilege. Now, we should take a breath. This is a tribunal, not the High Court, and it's an immigration tribunal, which is certainly not as persuasive as a tribunal that deals with these matters specifically. But it does get better, because here in Australia, there are 2 similar judgments in a family law context, which also warn of the potential waiver of privilege if documents are entered into an open AI program. Now, I'm not a lawyer, so I can't speak to the jurisprudence, but I'll include the links to the cases in the description below. This is persuasive, but it's not a binding legal precedent. So you could just ignore this and keep uploading your documents to OpenAI and Claude. But I wouldn't recommend it, because when something is genuinely contested in the common law world, courts in different jurisdictions tend to look at each other and borrow each other's work. And on this particular question, uploading privileged material into a public AI tool, the courts have been agreeing with each other. In February of this year, US Federal Court did something similar, and again, the facts of the case were different, but the court arrived at the same position. So here we have a signal from 3 jurisdictions. We got the same answer from 3 different starting points. So when you get English judges, Australian judges, and American judges all starting to line up on the same side of an argument, you should start to see which way this will go. But let me take this one step further and imagine what the tech industry's response will be. They'll use this to create additional revenue. It's a bit different to what we have today, because they're going to need to guarantee full segregation of your prompts from everybody in a way that's not done today. And that won't be cheap. They'll make you pay through the nose for that. And to do that, they're probably going to turn on the fear engine all over again. It's a bit like the problems with the Windows security model. Instead of fixing the problem, they'll keep the problem there and then sell you the solution as well. Because to them, a win-win means charging you twice. Of course, the other alternative will be local AI, which is about running your own enterprise LLMs on your own hardware. These are models that never touch the cloud and therefore can't expose confidential information or destroy legal privilege. In fact, I've already had subscribers reach out to me wanting to learn more about how they can run models locally. And I've started building some of that content already, which of course I will share on this channel. It's fascinating to watch these developments roll out in real time. But remember, Silicon Valley's playbook is to move quickly and break things. The problem is, though, that they're not the ones who have to foot the bill when things break. That's left for you and me to worry about. I'm Dr. Errol Brandt. Thank you for watching, and I'd love to hear your thoughts on what this might mean in the comments below. Even if you disagree with me, Please like and subscribe, and I'll see you in the next one.